Hi everyone, this is attorney Arkady Frekhtman. I'm a New York City personal injury trial attorney, and welcome to Last Week Tonight, where we answer your questions and we talk about your comments. It's all about you, the viewer, on this episode. So let's get into it. Here's a question from a Jeffrey Johnson just 10 hours ago, and he says, Mr. Civil Justice #1 personal injury attorney on the East Coast. Oh wow, thank you so much. So I guess it's more of a comment than a question. And then someone else says, wow, you read the last question I asked. Thank you for the info, Mr. F. Oh yeah, you are very welcome. That's what we do. We're reading your questions. We're answering your questions. Keep your questions like, if you can, keep them a little bit like specific, tell me your city, tell me what happened, almost so I could picture it happening, like I'm watching Netflix and I could see it. I could see it happening like I'm watching a movie. That's always helpful because once I could see it in my mind, then I could better understand what happened and I can give you the legal consultation. And then also like tell me your injury, either what's hurting you or what the actual medical diagnosis is from your doctor if you know it. I mean, most people will know after a few weeks what their medical diagnosis is. The doctor will explain it. Like they'll say, hey, you have a broken ankle or you have a herniated disc in your neck or whatever the case may be. So, we're here for you guys. Okay, let's see what other questions. Here's a question from Vishal Narang. And he or she says, in my case, the truck policy is $2 million. I'm sure there is excess insurance or umbrella. Once my lawyer gets the discovery from the other party, can you sue for more since medical bills are over 1 million? Oh my God, medical bills are over 1 million? Well, yeah, I mean, if the medical bills are already over 1 million, that means that the injury must be horrendous, right? Nobody gets medical treatment that costs $1 million. I mean, you figure like a fusion surgery is like 100,000. So I don't even know how medical bills could be $1 million, but that must be a really, really bad injury. Yeah, if they have a 2 million policy, what I would do is I would send them a request for all the insurance, and the request or the demand should say, tell me all the primary policy. If the primary policy is 2 million, then tell me if you have any other policies like umbrella, excess, supplemental, concurrent, any other policies other than the primary, and how much is that, right? It could be like 5 million, it could be 10. If it's a big company like a truck accident, it might be big. I mean, I've seen truck accidents go for like 20 million, 50 million. There could be really a lot of policies there. And, I don't like to make cases about the medical bills. I mean, if you have $1 million in medical bills, obviously, you're going to ask for that back depending on what state you're in. But I don't like to make the cases about the medical bills. Sometimes the medical bills anchor down the verdict because most people have medical bills, let's say 20,000, right? And that anchors everything down. And the jurors think, well, 20,000, I'll give them the 20,000 for the medical bills. And then, okay, their injury, well, even if I triple the medical bills, well, now it's 60,000, but that's not much, right? So you don't want those medical bills to be an anchor to weigh down the rest of the case. So what I like to do is make the case about the human story, about the real impact that it had to your life, to your family's life. And then that could make it a huge case, right? A multi-million-dollar case. But this sounds like a multi-million-dollar case already. So yeah, I'd like more information. Feel free to text me, 347-566-9595. Let me know where you are. I'm happy to help you. I'm happy to get on the phone and just give you a consultation and, help you out. Okay, then Betty May says, could you talk about product liability cases? Yeah, absolutely. I mean, just generally product liability is when a product is dangerous. It could be the manufacturer of the product, the person who creates it or makes it. Could also be the store sometimes that sells it or distributes it. So yeah, I could do that. Actually, I was on a webinar recently. There was a continuing legal education from one of the New York groups I'm in. It's the New York Academy of Trial Attorneys. And what they did was they did an annual update. So this was an annual update on different things. Like they had medical malpractice, they had civil procedure, they had disclosure, discovery, they had ethics. And one of the things they had was product liability. Now, it might be a little bit more specific because it was a lot of the recent cases from 2023. It might be more than you'd be a little bit like nerd out. I don't want to nerd you guys out, but I could look over that and I could just talk about product liability in general, like what you have to prove, in the pattern jury instructions. I'll do a video about that. Absolutely. Yeah. Thank you for asking that. That's a good thing because it's a new topic, something we probably haven't done before. Maybe I did a few on product liability, but not anything, I haven't done too much about that. So I think that's a welcome topic. So thank you for asking that. And then Lord's Child says, I'm in the negotiation process now, trying to settle my case. And it's very stressful and aggravating. And I said, good luck to you. I hope you get the maximum. Yeah, I mean, remember, negotiation does not have to be stressful and aggravating. It's only stressful and aggravating because the other side, the defendants and the defense lawyers, want to make it stressful and aggravating. And if your lawyer is just going to cow down to the insurance company and to the defense lawyer, if they're afraid of them, if they're going to be like a pawn that the defense lawyer is going to move, then they're going to pass the buck to you, and they're going to put the stress on you. A lot of the times these defense lawyers will say, hey, let's go to a mediation. We're going to settle the case. You show up to the mediation, you spend like $2,000 to be there, and then they say, you know what, this is a small case. We're going to offer you $50,000. And meanwhile, you're thinking, hey, this is $1 million case. So you get upset. Your lawyer is telling you, hey, that's all they're offering. And then you get upset, you get disheartened, and that's their goal, right? That's what they want to do. They want to make you feel like your case is worth less. They want you to leave there with a bad taste in your mouth. Now, hey, you thought you were going to get a lot of money, but you're not. And now you have a long road ahead, like many, many more years to litigate this case. And then they'll say, okay, maybe we'll do another mediation. And then they'll offer you like $100,000 at the second one. You see, so they want to slowly go up, inching slowly up, but keeping everything low. So even if they might have like a $5 million policy, they want to offer you like $50,000 and then maybe go up to 100 and keep everything low and not be fair. So what I like to do is I don't just start negotiating with them. I either send them a letter, once I have all the information, I say, hey, here's all the medical records, here's all the photos, here's all the witnesses. I don't hold anything back. I give them everything. And I say, look, you have all the evidence you need to evaluate this case. You have 30 days. We believe this case is worth $2 million. Pay us the $2 million in 30 days. If you don't want to, we understand, give us your reasons why, give us a good faith offer. Maybe it's not worth $2 million, maybe it's worth 1.5. We're open to the negotiations. Give us your good faith offer, but you have 30 days. After the 30 days are up, the $2 million is off the table, and there will never be another chance to settle this case for less than $2 million again. Once those 30 days expire, the minimum we would even consider is $4 million, right? And that gets them going crazy. Their minds are exploding because they're like, oh my God, they just flipped the script on me, and then you don't have to be stressed. You don't have to be worried. You don't have to be waiting on them to give you an offer, which they'll never give you, a fair offer, right? You're the one calling the shots. You're in the position of power. That's the way to do it. And then the other thing you can do is don't agree to even go to a mediation until they give you a good faith offer. So if I'm writing that letter and I'm saying $2 million and they say, okay, let's go to a mediation. How about that? In response to my letter, I'll say, yeah, sure, I'll go, but give me a good faith offer. If my demand is $2 million in that letter and it expires in 30 days, I'll extend to 30 days. I'll make it 60 days. Sure. I'll be professional. I'll give you the courtesy, but give me a fair offer. Give me $1 million offer and I'll show up, or give me, whatever, $850. Put something on the table. But I'm not going to show up there and then for you to tell me, hey, you know what, I'll give you $25,000. That's a waste of my time. That's insulting. So, so just tell it like it is. Be tough. These insurance companies will pay you, especially if you have a trial lawyer, a real trial lawyer. Okay, and then S. Saidia Benfare says, Mr. Frekhtman, I have a work comp injury and a personal injury at the same time. I got a settlement about my impairment because of a hamstring proximal tendon reconstruction. My question is, how much of a percentage does workers' comp get paid for my personal injury settlement? Yeah, I don't think workers' comp would get paid a percentage. Workers' comp may have a lien. In New York, the way it works is workers' comp pays for your medical care, and they also pay for your lost wages. So when you have your personal injury settlement, you have to pay back a lien. And the lien could be like 1/3 of your entire settlement if it's a huge workers' comp lien. So they have this thing called a third to the lawyer, a third to the client, a third to workers' comp. But that's only if you have a really big lien. If the lien is smaller, it might be smaller. You could also negotiate the workers' comp lien. Usually that's done by the personal injury attorney together with the workers' comp attorney. But I don't know what state you're in, but feel free to text me, the 347-566-9595. I'm happy to give you maybe a workers' comp lawyer that I know, either in New York or in your city, and they could guide you through it if you don't have one already. Okay, then Thread Up says, I have a question for you if you have a minute. I'm considering contacting another attorney. My current one is not working on obtaining medical bills. We have waited months on 2 bills. I'm told that's all we need. Yet now when I complain about the time it's taking, they tell me to call to speed it up. Also, my case manager went on maternity leave and didn't say a word. I've tried contacting her for a month and wasn't aware. My question is, if I go somewhere else or to someone else, would it be a smooth transition? Thank you for any advice. P.S. I'm the lady hurt in an elevator at my apartment complex. Yeah, so, I mean, the best thing to do, again, is to text me directly so I can give you a one-on-one consultation, because I'm the lady in the elevator, and I talk to a lot of people, so I don't remember exactly what city you're in or what injury it was or exactly who this is, but I'm happy to give you she says it's in Las Vegas. Yeah, in Las Vegas, I do know some really good personal injury lawyers in Las Vegas, so I could probably give you a recommendation. Actually, I know an excellent lawyer who actually recently got a $30 million verdict out there. So I could give you a really good recommendation, like the creme de la creme of the lawyers out there in Las Vegas. So yeah, give me a call or just shoot me a text, 347-566-9595. But to answer your question, I mean, yeah, the lawyer should be working diligently. If someone's going on maternity leave, that's fine, but somebody else should be taking over their position. Medical bills or medical records are fairly simple. There are companies that do it for attorneys. The companies just, process, that's all they do. You pay the company like, $20 a bill or $20 a record, and you input it into a computer, or you upload authorizations, and they go and they get it for you. It takes like a week or two. It shouldn't take months and months. Or some law firms do it themselves. So they have a paralegal or a legal secretary. It's just a cover letter with a HIPAA authorization. You mail it out, and then if they don't send it to you, the provider, the hospital, or the doctor doesn't send it to you, you get on the phone, hey, where's my medical record? Okay, now they're going to send it to you. They fax it to you, they email it to you. It's really not like rocket science. It shouldn't be holding up the case. But if you want a new lawyer, it should be a smooth transition. I mean, there's not really any way that the old lawyer could hold up the case. They could say, look, I don't want to be substituted. So what happens is, if you're telling the old lawyer, hey, I'm firing you, I'm hiring a new lawyer because I'm just not happy with the work you're doing, what could the old lawyer do? Well, he could call you and he could say, please don't fire me. I don't want to get fired. I'll do a better job. I'll improve. So then it's up to you. If you really think they're being sincere and they will improve, you can keep them. But it's unlikely, right? Because if you haven't been happy with them for like months and months, it's unlikely they're going to change. So then if you really are set on firing them, just go ahead and have the new lawyer handle it. The new lawyer sends them your signed authorization saying, hey, you're fired, transfer my file. They have to transfer your file. If they don't transfer it, the new lawyer goes to court and the court tells them to transfer it. Now, if they don't transfer it, they're going to get sanctioned, they're going to get, fined, they're going to lose any legal fee that they may have on the case. Because remember, let's say your case is worth, just for example, like $1 million. If that case settles for $1 million, you get the client portion, which is about $700,000, right? Roughly 2/3, $667,000. And then the other $300,000, let's say roughly, goes to the lawyers. But if you have one lawyer, all $300 goes to that one lawyer. If you have 2 lawyers, they split it, right? If you have 10 lawyers, maybe you were so unhappy you kept changing lawyers like every few months. The 10 lawyers all share it. But the point is that $300,000 is the legal fee, the attorney's fee for all the lawyers involved in the case. So even if you have 10, they split the $300. However, they want to split it, right? If they can agree. If they can't agree, then the judge will say, hey, you did a little more work, so you get 50, you did a little less, you get 10, and then he'll split up the $300 among the 10 lawyers, or however many number of lawyers you have. But the point is, the $700, right, the lion's share is yours. That's the client's share. That's the client's piece of the pie. That never changes. Whether you have 10 lawyers, whether you have 100 lawyers, it never changes. So changing lawyers doesn't hurt you. And it can't really delay the case unless the first lawyer just doesn't want to give it up. But remember, they're going to want to give up the file because they want their share of the attorney's fee. If they don't cooperate in the process, then the new lawyer will say, great, I'll go to the judge. I'll get a court order in like a week compelling you to transfer the file anyway. Now I'm going to ask for sanctions. I'm going to ask that you be discharged for cause, which means for a reason, because you're not cooperating. As an officer of the court, you have a duty to cooperate in the substitution process. Like in New York, we have CPLR 321B, right? It says that right in the civil practice laws and rules in the code. I'm sure every state has that, right? You can't just like hold a file hostage once you've been fired. So basically that's pretty straightforward. So yeah, you shouldn't have any problem with that. The most you could have is like a delay of like a week, and then they have to transfer your file. Okay, and then question here. What does it mean when your attorney says the defendants admitted liability? Yeah, so if the defendants admitted liability, it usually means that they're admitting that they are at fault. Depends on what kind of case it is. If it's a car crash case, it means that they are at fault, like they rear-ended you. If it's some other kind of case, like a ceiling collapse, they're saying, yeah, we knew about the ceiling, we didn't fix it, it collapsed on your head, but we're at fault. So they're not fighting you on the fault, but they could still fight you on the damages, either by arguing that the car accident didn't cause your injury, right? Like we hit you in the back, but it was a little fender bender, and whatever you're claiming to your back wasn't caused by us. It was just there already from living your life. It's known as degeneration, or the normal painless aging process. And then your lawyer has to fight back with your doctors and prove them wrong, right? Or they could say, but that's basically or they could say, look, we did cause it, your injury. It was caused by us, but it's just not that bad. It's not worth much. So those are usually the defenses that they offer. Okay, and then Johnny Fogel says, the people's champ. Oh, thank you. Thank you, Johnny. And then Frankie says, can you open a cumulative injury case for psychological reasons while you're on a specific injury case? Basically, can you have two cases at once, workers' comp? Appreciate your videos. Yeah, I mean, you could have two cases at once, as long as they're for like different, I'm not sure about workers' comp, because remember, I don't do workers' comp. I just do I do work accidents, but I do the third party, the personal injury part. So if you're injured at work, I could help you sue the third party, not your employer, but the third party that was negligent. The workers' comp, I have excellent workers' comp lawyers I work with, I partner with them, they'll do the workers' comp. But remember, workers' comp is really administrative. All it is you go to a workers' comp hearing and they just authorize payment of your medical bills and your lost wages. That's all it is. And then you can get a Section 32 lump sum settlement for workers' comp, which is, based on the severity of the injury. But it's all an administrative system. So to do that, you need to do a lot of volume. It's like, thousands of cases they're handling. And I don't have time to do that kind of volume on comp. So I just do personal injury. But I work with excellent workers' comp lawyers, some of the best in the city. So that's never a problem. So yes, he's saying, can you open this kind of case? And he says, I was hit by an 18-wheeler while driving my vehicle to work while on the clock. Yeah, I mean, if you were hit by an 18-wheeler, that's obviously a workers' comp case, but it's also a third-party case because you're hit by the 18-wheeler while driving your vehicle. So you could sue the 18-wheeler as a truck accident negligence case. That's a great case. And then you could also get comp. You can get your lost wages and your medical bills paid for by comp. So depending on where it happened, just let me know where it happened. Text me, 347-566-9595. I'm happy to help. I could get you a lawyer in your city. We work with some of the top lawyers all over the country. And we get, just the last few weeks, I've been talking to people from like Arkansas, Mississippi, California, Florida, Texas, people from all over. Even like, I think somebody called me from Green Bay, Wisconsin, the Packers. I've never been there, but, I found out who the best lawyers are out there through my groups, because I'm in a lot of groups. Last week, I was actually at the Tri-Lawyers University. They had a huge summit, and it was actually in New York City, so it was easy. I got in the train. It took 40 minutes. I live out in Long Island. It took me 40 minutes. I was in Midtown, and I met a lot of the lawyers at the Tri-Lawyers University. This week, there's one of the American Truck Accident Attorneys. Actually, it's going on right now as I'm speaking. I had to miss it, but I'm going to try to get some of the notes and the recordings and watch some of it. I'm going to go next year. Just had to miss it because of some commitments at work. And then there's a few other groups. There's like Trial by Human. There's Tri-Lawyers, Tri-Lawyers for Justice. There's so many different groups, so many different, there's Trial School, which is a really great organization. They're doing something, I think, in November. There's always like some conference going on or some education that you can be involved in. Okay, and then Paul Dottie says, how long does it take to get a settlement check in New Jersey? I'd have to check that. You can probably just Google it, to be honest, from some New Jersey lawyer will tell you. I don't know. In New York, it's usually 30 days from when you sign the release. So you want to sign the release, which is a duly executed and notarized release saying that you release the defendant from any and all claims in exchange for the amount in the settlement, right? Whatever the amount is. And then they're going to send you the check within, I believe in New York, actually, it's 21 days under the CPLR. But, usually, they usually take about 30 days. Standard is usually what it is. So basically, I'm assuming New Jersey is the same, but we'd have to Google it. I don't do New Jersey. I have partners in New Jersey, also some of the best lawyers in the country, but I don't do it myself. Okay, and then Young's World says, I talked to my lawyer and he said my case is in litigation and they have 21 days to respond. Can you tell me what that means? So basically, yeah, I mean, probably he's talking about litigation. They have 20 days to either give you documents, 21 days. A lot of things are 21 days, 30 days, basically to respond to something in the discovery order, to set up a deposition, something like that. And then he's asking about amount of money. They're asking for the same amount. Yeah, it's hard for me to say about like what the value may be without, really getting into the nitty gritty and finding out and reading the case file. Okay, and then Nate the Great says, update on the info you provided me on how to find my case on e-law. It worked perfect, thank you. Considering we won summary judgment on liability, the defense has to pay 9% interest only if we go to trial? Well, yeah, I mean, yeah. If you go to trial and you get a verdict, the verdict can include 9% interest on the amount, but the 9% goes back to when you won the summary judgment. So for example, somebody could be involved in a car crash, right? And then you could file the lawsuit like a few days after the crash. If it's a clear, serious injury, well, why not, right? And you get summary judgment, now you have a judgment. You can get a judgment maybe a few weeks after the crash, right? So then the case could go on for like 3 years or whatever, 5 years, whatever it takes, 8 years, whatever it takes, doesn't matter. And then at the end, you get a verdict like $1 million. You tack on 9% on top of everything from the date that you got the judgment, which was just a few, days after the incident. So it's a very, very useful tactic, and they get scared because like, oh my God, I'm gonna have to pay all this interest. But yeah, I mean, if you settle it, they usually don't pay you the interest as a settlement, because a settlement is like an agreement. We settle for an amount. I mean, you could try to negotiate that into the settlement, saying I have summary judgment, so pay me more, pay me a premium, because well, why not? If I go to the jury, I'm gonna get the judgment, so why shouldn't I get it from you? Okay. What other questions do we have? Maybe I'll just do 1 or 2 more questions. Here's a question from Terry. I would like to hear about fall at work wearing all proper safety equipment, requesting the foreman to supply adequate people to assist with working in a tunnel without any electricity. The foreman refused, even claiming they are bound by adherence to OSHA rules, resulting in TBI, nerve damage, traumatic cataracts in both eyes, causing blindness before even receiving disability, all on workman's comp case. Accident report within 1 hour of a fall, 8 years later, still waiting on settlement. Yeah, I mean, so he wants to know about a fall. Yeah, I mean, I'd have to see like what caused the fall. I understand about like what he's saying, but I'd have to understand what caused it. Was it just the fact that it was dark, or was there something unsafe in the tunnel? And also where it was. Was it in New York? Because in New York, we have the labor law, which really protects the construction worker, whereas another city or state may not have that, right? So that would determine, everything would change depending on where it happened. So feel free to text me, 347-566-9595. I mean, definitely a workers' comp. You might have a third-party lawsuit as well. Okay, what other questions do we have? Here's a question. Can you explain common carriers, specifically elevators being misleveled? Yeah, well, elevators aren't common carriers. Common carriers are more like railroads or buses, right? They're carrying like public transportation. Elevators are just premises cases usually. So you sue the management of the building. You could also sue the elevator company. And if it's misleveled, there's usually you get an elevator expert to examine it and to figure out, hey, why did it mislevel? Maybe there's something wrong with a pulley or something with the elevator, and then it's a defective condition, and then you hold them liable for failing to repair it, especially if they should have, using reasonable care, they should have done an inspection, found out what the issue was, and fixed it earlier, and then you wouldn't have gotten hurt, right? So, and especially if they knew about it and they hid it, right, then it's even worse. Then it could be even bigger verdict. And then Breakfast Toodle says, I recommend this lawyer. I had a free consultation with him and was impressed. Wish he was in my state. Oh, thank you so much. Yeah, absolutely. Just text me. I'm happy to give you a personal consult, whether I'm in your state or not. If I'm not in your state, like I said, I work with a lot of the top injury lawyers all across the country. We've gotten some excellent results. Recently, we got a case, I think down south, maybe near Atlanta, and it was like a $2 million result because I had one of the best trucking lawyers in the whole country handle it. And it was a $2 million result for one of the YouTube viewers, so it could work out even if it's not in New York. And then Blue994 says, hello, sir. What's after a demand letter? A demand letter sent 2 days ago by my lawyer. Okay, yeah, so usually after the demand letter, you want to wait, like I said. Well, I don't know how it's worded, right? If it's worded like my way with the 30 days, well, you know, hey, 30 days, you're going to get your answer. If it's just open, then you have to wait on them, right? They could never respond to it, and then you have no teeth, right? Nothing happens. So there's not really any procedure or process that follows a demand letter. It just depends on how you structure it. If you don't give them a deadline, you know, you could just call them up and say, hey, did you get my demand letter? What's your response? And they could say, okay, my response is that I'm going to pay X, or my response is, you know, 0 or whatever, or my response is I took it, I crumpled it up, and I threw it in the garbage, right? They could say anything. So there's no real, like, demand letter is not really part of the lawsuit process. It's more like a side attempt to try to settle the case. So it could work, it could not work. So, you know, what I would do is I would follow up with your lawyer, and if they don't really give you a fair offer, then just keep litigating it, do depositions, put it on the trial calendar. And then she says here, they gave me an offer without a lawyer, and I didn't like the offer, so I got a lawyer. Oh, I see, and the lawyer sent a demand letter 2 days ago. And this was a commercial truck. I'm dealing with travelers. Yeah, I mean, a box truck with travelers, yeah, travelers is usually pretty fair. I get the lawyer, I mean, as long as it's a trial lawyer, make sure it's a trial lawyer who's going to file a lawsuit. I don't know, they get a lawyer, and the first thing they do is send a demand letter. That's kind of weird. It's like, oh, please give me some money. I wouldn't do that. I would file a lawsuit, you know, show them, you know, you're in business, file a lawsuit, get it going in court, send them some requests for discovery, you know, put them on their heels. And then, you know, you could say, okay, now pay me $1 million or whatever you want to get. I wouldn't start off with a demand letter. I don't know. That's kind of like weird. But, you know, every lawyer does it their own way. Okay, and then Notorant says, once again, the Bronx is where it's at, LOL. And he's talking about a case, a video about don't make this $1 million mistake with your lawyer. And he says it's like a gold mine. Oh, yeah, the Bronx. Yeah, the Bronx is a good place. You get good juries, big numbers. But it does take a long time, unfortunately. It's slow. Okay. What other questions do we have? Maybe I'll do one more question because we're almost at the half-hour mark. I mean, how do I speak to you directly about my case and get your opinion? I'm in Vegas. I have a big case. Oh, yeah, absolutely. This is, again, Vishal Narayan. I think we read a question from him earlier. Her, yeah, just text me, 347-566-9595. Best thing to do is just text me. That way, I'll text you back. I usually text everybody back like right away. And then I just ask you like, hey, when is a good time to set up a consultation? You tell me when, and I'll try to make it happen, or I'll give you some times I'm available. And then Arkady Bal Harrison says, you're a great man. Oh, thank you so much. I really appreciate that. That means a lot. Thank you. I try to help as many people as I can. Vic Centeno says, awesome tube today. Thank you so much. Mike Richards says, thanks for the absolutely positively spot-on analysis in this video. There are attorneys who are negligent and not genuinely working on serious personal injury cases. You're such a conscientious and loyal attorney, and we appreciate you. And he's talking about that same video, the warning, don't make the $1 million mistake. Okay. Yeah, so I think that's good. So we're about, I think we did all the questions for about a week. So we did last week tonight. Okay, thank you, everybody. Let us know what questions you have. Leave a comment. Remember, try to make the comment a little bit specific, like so I could see what happened, and tell me your injury, and tell me your city. And you don't have to use your name, of course, in a public comment like that. You could just say, hey, it's whatever, Joe Blow from Milwaukee, and I had a trip and fall on a sidewalk because there was an unsafe elevation. One of the sidewalk plates was higher than another. It was a defective condition, and I suffered a herniated disc in my neck. You know, then I could give you some feedback, and then if you want a private consultation, just text me, the 347-566-9595. Okay, everybody, have a great day. Stay safe out there. Big verdicts if you're going to trial, and big settlements if you're negotiating. All the best. Get better if you're injured. I hope you get a full and safe recovery, and all the best to everyone. Okay, bye-bye.